So we will be doing the IP rights on social media, and we will be with Jill Lewis, who is a partner at Perkins and Coie, Ricardo Bonilla, who is principal at Fish and Richardson, Jhaniel James, who is associate at Womble and Dickinson, and Mark Johnson, who is corporate counsel at Microsoft. Jill Lewis focuses her practice on advising companies with growth-oriented liquidity creating and transformational strategies. Her experience includes leading strategic transactions for entrepreneurs, private equity sponsors, and portfolio companies, as well as members of the Fortune 50, with a particular emphasis on infrastructure, multi-location retail, transportation, manufacturing, and industrial sector matters. Jhaniel James. Jhaniel represents clients in all phases of intellectual property disputes. Her litigation experience includes the full spectrum of patent, copyright, trademark, trade secret, and unfair competition disputes in federal, district, and appellate courts. She has experience litigating technology relating to automobile infotainment, multi-factor authentication, computer networking, and USB communication. Ricardo is a litigation attorney focusing his practice across all areas of commercial and intellectual property litigation with an emphasis on patents. Mr. Bonilla currently serves as the firm's recruiting principal in Dallas and co-chair of Latinos, the firm's Hispanic Latinx legal staff affinity group. Mr. Bonilla is also head of Fish's Next Gen initiative, which provides a voice and opportunities for newer lawyers and ensures proper training for Fish's associates. And last but not least, Mark is a corporate counsel at Microsoft, supporting the company's Cloud Plus AI business planning and commercial licensing teams. Mark's practice focuses on advising internal business clients in the development of innovative business strategies about the deployment of cloud-based technologies and products, the brokering of market-defining and disrupting partnerships and deals focused on market creation and infiltration, and the development of Microsoft's commercial licensing agreements and strategies. So technology.
Oh, so here we go. Sorry, it would help if I didn't mute my microphone. One day, I promise. I know we've been in this pandemic for over a year and been working remotely for over a year, but if you had somebody was muted on your bingo card, you can scratch that off now. So I'll start. We're here to talk about IP rights and social media, and obviously the social media landscape has changed dramatically, even in the last 5 years, even the last 2 years. But the law hasn't quite kept up with it, and so it's left us with a lot of questions about what happens with material that folks post on their social media, what protections do they have, and what potential effects could posting have on intellectual property rights in particular. So as one example of just how far kind of behind the law is, the DMCA, the Digital Millennium Copyright Act, was signed into law in 1998. I don't know how many of you feel this way, but I always think the 1990s were 10 years ago. 1998 was 23 years ago. So it's been a long time since we've had an update in the law to reflect the significant updates that we've seen on social media. If you go to the next slide, please. So we've come a long way, obviously, since Napster. There's a concern about copyright infringement. There were, all those applications, software you could use in the late 90s to download music, to share files, and those actions have a lot of implications with intellectual property rights. They have a lot of implications outside of that as well, but we're going to focus on those. And we're in an odd place right now, right? We're in the middle of a pandemic, but to be viral is actually desirable. It's a good thing to be viral. And we've seen a decline then in traditional media channels, which is what the law is really focused on. And the implications of that aren't widely known or even widely considered. One example, I had a client who called me talking about wanting to potentially have trade secret protection over some software that he was developing. And we started talking about the development that he was doing. And it turns out that he was developing that software on his Twitch stream, which is broadcast publicly. which for anybody who knows about trade secrets, once it's in the public, it can't be a secret anymore. He had other options, of course, for protection, but that just didn't enter the mind at that point, because he's sitting there thinking that he's got this Twitch stream and there are 2 or 3 people at a time who are looking at what he's doing, which is drafting this code. But because it's public and publicly accessible, and because his public Twitch stream was publicly ascertainable, anybody could find it, it would be very difficult to get trade secret protection in that case. So there are a lot of things that people need to keep in mind when using these social media platforms, if the end goal eventually is to have some intellectual property rights attached to whatever it is that you're working on. Next slide, please. So before we talk more about the rights in particular that we've seen with intellectual property and the questions that social media gives rise to, I'd like to kind of frame our discussion to keep in mind that social media is also evidence. It can be used in court, it will be used in court. And on this slide, we have a few examples. On the left-hand side is a picture of a gentleman who at one time worked at Taco Bell. Then he posted this picture of him licking Taco Bell shells while at work. He no longer works at Taco Bell. In the middle is an example of somebody who tweeted that they got a job offer from Cisco, but they were having to weigh whether they wanted to get this fatty paycheck with whether they wanted to work someplace with a terrible commute and a job they would hate. And of course, folks responded and said, oh, well, we'd love to tell your hiring manager that you think you're going to hate the job. And then the most recent, or at least the most glaring example, is the events of January 6th. The photograph on the right is a gentleman sitting in Nancy Pelosi's office, the Speaker of the House's office, where he took an envelope off her desk, and then he posted a Facebook live stream of him doing that. The FBI has had a plethora of evidence in the charges they brought relating to the events of that day, specifically because people keep posting them online. So you have to keep in mind that whatever you create and put into the public sphere, it can be used as evidence. Next slide, please. So just a couple do's and don'ts, right? A do is to make sure you preserve discoverable social media information. So if there's a threat of litigation or you're considering litigation, you want to preserve all of the social media links. Now, there are certain local rules in various district courts that will explicitly state that things like text messages or things like voicemails, that those are too onerous to save or to preserve. But for the most part, anything that is created that's digital, that's publicly accessible, you want to keep. And an example of this is the case of Ms. Torres. So this is a case from out of the District of Puerto Rico. Ms. Torres was suing a company civilly for a sexual assault that she said resulted in her mental anguish and embarrassment. And she stated during discovery, when she was deposed, that she led a very reclusive life and that she was, she barely had any social media presence because of what had happened. Well, it turns out that that wasn't exactly true. And when the other side, when the defense counsel found her social media accounts, they found somebody with an aspiring modeling and singing career who posted multiple times a day. It was in direct contradiction of what she had stated in court or during her deposition. That, when she found that out, she then deleted all of her posts, which led the court, not surprisingly, to allow the jury to have an adverse inference. It said, you're not going to be able to put forward any evidence of your mental anguish because of spoliation, because you deleted the social media evidence that was important here. So that concern is something that everyone should keep in mind, that it's not just important to keep in mind what you put forward and what you post in social media, but how long you keep it there, how you preserve it, how you maintain it. So do preserve any social media. Don't create new social media in the midst of a dispute. So the example on the right is a case of a woman named Miss Lentz. She sued Universal because they sent her a takedown notice. She had posted a video of her toddler singing with a song in the background, and you can see a screenshot of the video. And so she got a takedown notice because she was playing copyrighted music on her social media platform. And she sued to say that that was incorrect, that she shouldn't have been required to take it down. When during the lawsuit, though, she was posting on her blog about the lawsuit. Even worse, she was posting about conversations she was having with her attorney about the lawsuit, which led the court to state that she waived her attorney-client privilege in the case. And that case was very soon after dismissed. So don't discuss ongoing litigation. Don't create new social media when you're in the midst of a dispute like this. So the reason that we go through this initially before I turn it over to Jhaniel is that you want to keep in mind the context here. Like anything that you put in on social media is going to be public. If it's public, it is discoverable. Even if it's private, it might still be discoverable, but public, it's definitely discoverable. And if it's public, it has a direct effect on your intellectual property rights. The example of my client and his software that he can no longer get trade secret protection for. When things are posted online, it adversely affects, or at least materially affects, whatever intellectual property rights you may think you have in the material that you've created.
Hey, before Jhaniel jumps in there, I just want to, we want to extend some grace and mercy. I am going to step in as your moderator, the original moderator, Jill Lewis. We are trying to get her in now. And yeah, I do things different. But Jhaniel, let's come to you. Before we leave, though, Ricky, because you mentioned some stuff, I'm just curious, what rights, and maybe this is going, if it's going to be covered, you all tell me, we getting there, Charlie. What rights do consumers have to prevent social media companies from releasing their information to the police or the feds? Are we going to address that later? All right, good. Let's go.
I didn't have that in my in the actual slides here, but that's a really good question. And first of all, hey Charlie, it's good to see you. Haven't seen you in a while.
Hey, brother.
And second, so when for the most part, there have been attempts to get social media platforms to provide evidence against their customers, and those have been blocked because for the most part, those individuals, for example, we talked about the DMCA in Title II of the DMCA, which shields platform providers from liability. So just because they are hosting information that's posted by somebody else doesn't mean they can be liable for what one of their users posts. Just like they can't be liable, they also can't be forced to turn over that information. Now, the state of that law is very much in flux because there are a lot of cases out there where there have been attempts in criminal investigations or in civil investigations even to try to get at, for example, the information that Amazon has collected on you if you've used Amazon, or there was that very famous case of the Google Home being used in a murder investigation, because when you speak to your Google Home, it sometimes will record the information, and that could be stored somewhere and used later. For the most part, at this point, I think it's fairly safe to say that trying to get that information, the user's post information, through the third-party platform provider is a very uphill battle. And unless the law changes dramatically, I don't think you're going to see a lot of that happening. But the attempts are still going to be made. And keep in mind, you may still have an obligation to provide the information yourself. If you posted it and you have access to it, you may have to provide the information yourself, even if they can't make your third-party service provider do it for you.
Okay, great. I just want to make sure for those who are considering careers in tech and law, and for the students, that we could put the building blocks together. We've talked about the CCPA. These are the rights you have in data. We had a great overview with AI that shows that really, and I'm a believer, data is the new oil. Data is king. So if they have and now we're talking about social media and IP rights. So I just want to make sure they understand where it fits. Jhaniel, sorry, my apologies.
on brands. Oprah's always been there, so gotta always count Oprah in. But like celebrities and things like that, that's who was an influencer. But now, if you just take a lot of good photos or something like that and put hashtag influencer, you can draw a crowd and become a weighty producer. And it's interesting because that idea also kind of interacts with how governments react to platforms. And that's what I want to talk about here. You guys may be familiar with the Australian case around news media. It's evolved a little bit since we built these slides, but I wanted to highlight that for you. So in Australia, they passed now this code that would require digital news or digital platforms to pay for news content, which is a very broad term, that's published on their platforms that was originally produced by a publisher. And that's a huge change of paradigm. You think about, you scroll through your news feed or something like that. All the news media, which we'll talk about how broad that is, being paid for by the platform because you put it up there, not because the platform chose to put it up there, but because you put it up there. And that, goes in a different direction from previously. Like if in the Napster days, if I shared a song on my MySpace, I guess that was the thing back then, I could be liable for publishing that song. But now it's Facebook is liable for what I do on their platform. And so naturally, the platforms reacted very strongly. Initially, Google said, we're going to pull out our search engine from Australia. Not going to be able to get Google search in Australia. Too bad. So sad. Like, good luck, Australia, living without Google. And Australia was like, well, all right, well, we're not going to blink. And the time kept ticking down. And then Google was like, all right, I'm just joking. Let's go ahead and start making some of these deals with these news publishers to enable us to publish on or publish the content published by or produced by them, published by our users on our platform. Let's make that happen. The law requires that negotiation conversation to happen and has some backstops for if a deal isn't reached. And that's what really got Facebook's reaction, which was they're like, so you're going to tell me I've got to pay for this stuff. I've got to make deals. Google's like, we can make deals. So we're going to go ahead and do that. And then if I don't make a deal, you're going to tell me how much I have to pay. And so Google, whereas their reaction was to go ahead and start making deals with publishers, Facebook's reaction was to cut all news media off of their platform. And following the broad definition of news media under that law, that included anything from, just a run-of-the-mill news article published by, anyone to Facebook posts or Facebook groups run by the Australian government giving updates about the COVID situation or giving updates about best practices around COVID or anything like that. So this huge gap happened over the course of, I want to say a couple weeks, probably a week or two, around what was accessible in Australian news media. And this didn't just affect Australian users. It meant that not only all global content that was called news media was not available to Australian users, but any Australian news content was not available to global users. And so there's this huge black hole, Facebook-wise, in terms of what was accessible. And so this, this quickly freaked everyone out and showed how frail, I guess, that empowerment of being a publisher through Facebook is, because they'll let you use their platform and you can publish things, but they kind of ultimately hold the switch. And given how broad the user base of Facebook is, that freaked a lot of countries out, because you think about the media that's been shared on Facebook and how that's influenced US elections and things like that. They were thinking, oh my goodness, now we're really seeing that Mark Zuckerberg has the ability to really influence the information sharing in our economy, in our politics. And what does that say for our dependency and what's left? If we don't get Facebook in, what do we have to to fall back on, especially after years of decimation of the news media because of these platforms. You know, they did a study where they said that for every $100 being spent in Australia for advertising, because you know this is all driven by advertisers spending money on who is getting the most clicks, who's getting the most views, and things like that. They want to see your eyes going to the side of the page looking at that advertisement. For every $100 that was being spent, $49 was going to Google, $24 is going to Facebook, whereas previously $100 was going to Australian data companies. And when that progressively closed down, those companies dried up, which is what this law was meant to address. Now, Google's reaction is actually flagged as, you know, this is a good compromise. And it's interesting because as the situation evolved, Facebook eventually capitulated. They got some compromise out of the government by saying, you know, when you tell us what we have to pay, you'll consider how much money we've spent on media and supporting democracy and things like that. That'll be one of your considerations. And the government was like, okay, whatever, we'll do that. And, you know, in exchange, you got to tell us whenever you change your algorithms so that you don't rank things in weird ways and try to manipulate our economy. And Facebook was like, okay. So it was kind of like not a really big change to the law. So Google accepted the law as is, started making deals with News Corp, which is Rupert Murdoch's organization, and a few other large publishers. Now, here's the thing. That sounded like a really great thing. Like you all, us all, can publish News Corp media now. You know, and Australian users can see News Corp media and everything. But what happens to the smaller producers that don't get to make a deal with Google because Google's like, you know what, you don't get enough clicks for me to care about you. We're not gonna make a deal with you. And oh no, I can't publish your content. Like that's the end result. And so what happens is these smaller, more minority voices get frozen out, get kind of put to the side because there isn't this mandate that you have to pay them. There isn't this mandate that you have to support these news media outlets. And so slowly, everyone gets mainstreamed in terms of content. And if you guys, I got relatives who probably shouldn't have Facebook. And I know that they get a lot of their news from Facebook. And it makes me scared that they're only going to get a certain message from Facebook, and that message is going to get narrower and narrower, albeit maybe it's more of the middle road or something like that. But like that is what's happening when you think about the sway that these platforms have. And yes, we're publishers. And yes, we could be influencers and things like that. But ultimately, it's at the hands of, you know, these large companies. So what would have been a better law? And folks are starting to debate over this is, you know, what if they just did a tax? You know, there's a pool. If you be registered by the state as a news publisher, the state would give you, you know, some sort of support or something like that. It's a little hard to make something like that work, but you know, we are where we are now with this new law. It's still being tested out, but you see how this string of who are being empowered by news or by social media, you're being empowered by social media, has its bounds, has its limits. And one of the kind of lingering thoughts that I'll leave you guys with is the definition of a news publisher is fairly broad. You know, in the case of the Australian law, you have to be registered with the state to kind of take advantage of some of these. You must bargain with folks. You must bargain with this publisher type of thing. But we just talked about how powerful media influences are, or social media influences are. If you can imagine, you know, Jhaniel being this like Oprah 2.0 and like producing content and all these things, and Facebook would theoretically, if they want to produce the media that she's sharing, the news media and things like that she's sharing, they'd have to go and make a deal with Jhaniel. And so you still are a publisher. It's just that once you pull, because of things like this, where they're trying to solve these complex laws, we started off by talking about the DMCA and how that is 23 years old. It's not really doing it, but they're trying to catch up. And this is an example of that, but they're still not doing it well. And you get these kind of funky situations where the news media on the engines are getting cut out, but also, you know, Google may have to go and negotiate with Jhaniel if they want to, you know, republish her. I don't know what you would what you post, Jhaniel. But you know, that's one aspect of it. But then you think about to Charlie's question earlier, social justice and the intersection of social media, what about a video of a police officer putting its neck on an individual's until he passes away? Is that news media? Can Facebook say, you know what, we're not going to pay you for that, and that message, that information is not going to get shared? Like, is that possible under these paradigms? Is it possible that I could witness something, write an article about it, want to share something about a minority experience that interacts with justice, and someone say, we're not going to pay for that to be published, therefore your audience is this? That's one of the cool and scary things about this, is that as we get integrated into social media, we get empowered by social media, we're also limited by the whims of these companies. So I'll leave you with that. It's kind of dramatic, but that's how I saw the situation.
No, not dramatic at all. It fits perfectly, Mark. I love it. You just teed it up and framed it up. I want to say, Mark, for president, you raised very interesting issues. And I mean, just going along your scenario, what happens if I just happen to be the one to catch the next George Floyd video? The police are demanding it from me because it's evidence, but I know on the other side, I could get paid from Facebook, CNN, everybody else. You want this video. Where do we find that balance? Is it right for the police to just be able to take that evidence, that video from my phone, my intellectual property, say this is actual evidence now, and so they do with it what they want? CNN comes and gets it from them, pays them, or gets it for free, and now I, the person who created the intellectual property, who pays my phone bill, allowed you to hijack my phone, you just took revenue from me because TMZ was going to pay me $20,000 for exclusive footage of that video. You guys have just raised wonderful issues, and I got all kinds of questions. So I know I'm not your moderator, but I'm just gonna let's come off mute and let's talk. That's what we like to do. I heard a myth that once you hit 10,000 followers on certain social media platforms, you can monetize your content and get like advertisers. Is that accurate? Is that true? Because I'm sure we got some social media influencers on the call right now.
So I'll let Ricky and Jhaniel, if you guys know the answer. I have guesses, but
yeah, I'm guessing too. But that's why I said it, a myth. I'm not sure. Jhaniel, you got something?
Well, I think the term influencer is actually pretty broad in terms of the amount of followers that you have and what you can monetize. So there are definitely influencers like the Kylie Jenners, the Cardi B's, who have millions of followers, but there's also micro influencers who may have 10,000 followers or less. I think it depends on, in terms of advertising, I think it depends on who the advertisers want to reach, and if there's a particular interest that this person who has a certain amount of followers reaches. So I guess there are mommy blogs, there are sports or gym rats, or all these different areas of influencers. And so I'm not sure if the amount of followers limits exactly whether you can monetize. I think it probably definitely limits how much you can make if you're not reaching a broad enough audience. Does that answer the question?
Yeah, no,
yeah,
that
I
helps.
think if I could add one thing to that as well, is what we've seen in a lot of cases is when you have these what Jhaniel termed micro influencers, sometimes those individuals get co-opted into being copywriters for those with larger bases to influence. So you may have a situation where somebody with an oversized influence sees that someone with a much smaller influence has really effective messaging and is interested in adopting that messaging. And so maybe you get them the smaller influencer to be a ghostwriter or a copywriter that provides content that then is broadcast into larger forms. And then it raises a question then, if I'm the smaller influencer and my content then gets retweeted by somebody with a much larger influence, where do the revenue streams go then? What does who does that property belong to? I think it's really curious to see what happens with that case that Jhaniel mentioned about Volvo retweeting information. I mean, what is the responsibility at that point?
I want to encourage all those who are listening. When you see a gap, this is reading the trends, and there seems to be a lot of gaps. We know that there are going to be, especially with the pandemic, a lot of content creators, people starting podcasts, webisodes. We don't have anything better to do sometimes, but we are creating content. It's getting out there, and it's still unclear. You know, can you release my content as evidence, as we talked about, Ricky? Are you going to protect it? We know there's instances where social media has been used in court, so that's kind of a gray line. You then also have this new Australian law, and I'm coming to you, Mark, because I know Microsoft had a stance on that. I know you're not here in your official capacity, me either. We just want to talk broadly about the implications of this, but there's a lot of gray area, and if data is king, data privacy and security is here, maybe you don't feel like you have the patent background, AI technical, you hate math, that's cool. But there are areas here in social media. And so my next question, because I do see some. Question to all speakers, with all these platforms you have been discussing, has the competition law and its checks failed? Are they simply too big to be regulated? That is a good question. Let's do rapid fire. Yes, no, yes, no.
I know that there's been calls to nationalize Facebook and Twitter at times. Whether or not something like that's going to happen, I don't think it is. I think that they've kind of amassed enough kind of a story that they are grassroots supported kind of enterprise, while at the same time, you know, it's a user-driven platform. And so to say that they are kind of manipulating the market, it's kind of like, well, our users really like us. Our users are what make us successful. And also they have a lot of money, so they can lobby really well. But at the same time, there are these cases before Congress right now, these investigations before Congress, to look at their influence and their sway in the market. And what I expect will likely happen out of things like that is there may be bounds drawn around how they manipulate the media that's produced there. It's kind of a very fuzzy area around free speech, but you saw around the turn of this past year with the whole crazy noise around the election, where Facebook, you know, kind of knowing like, hey, you got a target on your back because of what happened last election. They're like, oh, we're gonna take off no political ads, and we're gonna stop, you know, false information about false votes and things like that. And so they're trying to preempt a lot of this control that could come down in the state and that should have bipartisan support, but you know, it's kind of shaky at sometimes. They're starting to try to preempt that by taking steps. But at the same time, you know, news today is that Facebook has reinstated political ads. You know, it's a temporary measure where they kind of recognize that our attention's a little short, and they'll make these moves when it's most highlighted on, you know, the attention's highest on them, and then, you know, kind of conveniently go back to making money once the things have calmed down. So it's a really good question. And I'm not sure that we'll see, you know, a breakup of Facebook, but they may create some sort of conditions where it may be easier to create a new Facebook, but it's such a hard thing to do.
Well, you know, I think that we kind of started down this hill the moment, you know, you mentioned that these are user-driven platforms. Are they really? They're more AI-driven. They're algorithm-driven at this point. And the moment that you decide that you're going to weigh or raise the visibility of one post versus another, you start down the hill of, okay, now we have to ask these questions about what does that mean? The reason why we had Title II of the DMCA was because at that time in 1998, there wasn't this ranking, right? There's ranking when it came to searches, but on these social media platforms, when you showed up there, the thing at the top of your feed or whatever you saw back then was the most recent thing that was posted, no matter who it came from, no matter what the size of their base was, no matter your relationship with that particular user account. Once that stopped and we started focusing more on, well, what is not only the most recent news, but the news people want to see. You know, I go and open my Twitter feed and the thing at the top of my feed was from 23 hours ago, as opposed to 23 seconds ago. Once you start doing that, that's when those regulations have to start kind of trying to catch up, and we're nowhere near the ability to do that.
Good point. All great points. Jhaniel, you want to rapid fire that question?
That's always an interesting question for me that I have had conversations with people with. So I'm not really on most social media platforms. And the way that I get information from social media is that a friend will send me a link and I only review that link. So I guess I'm not really a customer, I guess, to an extent of social media. And from my perspective then, if people can easily opt out of using social media, what power does social media really have? And another point is, will Facebook be around forever? Will it go the way of MySpace or the plethora of other platforms that seemed like they were going to be something and then weren't? And so those are the questions that stick in my mind as somebody who's not on social media and participating and being I don't know, manipulated by bots.
Great question. I'm going to answer your question, and then I got another question because I want to make sure we bring in, again, the students as well and practitioners. If you haven't seen the Netflix show, The Social Dilemma, you need to see it. That's first off. Now, there you go, Ricky. You can unmute. I was getting an alert that you couldn't unmute. The other thing is, when we talk about lanes, there's something called persuasive technology. And you asked about, well, is Facebook going to be around and are they going to go the way of MySpace? The investment that they're making in persuasive technology, and they talk about it on this show, I think it is. That is the reason why you have people who are addicted to social media now. And this goes to liability as well. And why we spend so much time on social, it's because they've researched, and it's almost like gambling. You walk into Vegas and you think, how sad is this? Someone's grandma or grandpa is sitting there and the cigarette is almost down to the butt, and it looks like they've been there for hours and hours on end. And that is the way this persuasive technology is set up. And Ricky made a good point, or no, I think it was Mark. Yeah, when the spotlight is on them, no political ads. But as soon as you get distracted, we're back to making this money, and they get money for our attention. So my next question is, so Clubhouse is the new IT app. Can somebody explain what Clubhouse is for those who may not use social media? And then the question is, what if you are using this app to hold meetings to discuss like strategic business plans or intellectual property? You are pitching your content idea or a show idea. What advice would you have for content creators using Clubhouse?
Well, with respect to the advice, think very carefully about the information that you're discussing and whether you want to attach intellectual property rights to it and what right you want to attach to it. Right. I'll go back to the example of my client and his Twitch stream. He can't get trade secret protection, but he can still get patent protection potentially, depending on what it is that he claims. But the clock has started ticking. And so, and what I mean by that is, in the patent context, once you publicly disclose something, you have 1 year to file a patent application for it. So But then when you look at it from the trade secret perspective, the moment you disclose it publicly, you lost that protection forever, right? If Coca-Cola ever actually issued their recipe for Coca-Cola, it'd be gone. It would no longer be a trade secret. As opposed to right now, it is, oxymoronically enough, the most famous trade secret in the world. So you really need to be considering, when it comes to Clubhouse, I actually have never used Clubhouse. I don't know exactly how it works, but I know that it is something that is ascertainable. So there's a difference between accessible and ascertainable, right? Accessible is that there is a secret URL that if you know the direct URL, you can click on the link, you can type it into your browser and go look at it. Ascertainable is that it's not secret. I know what the information is just by, I know that if I type in gmail.com, I will go to gmail.com. So you want to be careful about who your audience is in an app like Clubhouse or even on Twitter or Facebook or anything like that. You want to be careful about what information you're putting out into the public sphere and who is hearing it, who's able to access it, and what IP you think you can attach to it. So there should be conversations before you ever step foot in the social media arena. What am I about to discuss and with whom?
Good advice. Mark, Jhaniel, did you guys? I'm going to assume, Jhaniel, you don't know what Clubhouse is.
I do know what Clubhouse is. What? I don't use it, but I do actually know.
Okay, come on, speak to us.
Yeah, I've heard of it. I agree with Ricky that you always have to be careful in what you're saying on any social media platform, and what you're disclosing in terms of intellectual property. I think one interesting thing about social media that we haven't discussed is around like disclosing information in a patent application that you're going to have, and when applying for the patent, the PTO may have access to that, and if it's beyond certain prior art time periods, it could work against you for your patent application. So yeah, again, seconding Ricky, you have to always be careful on what you're revealing, especially when it's public to some extent, to whatever extent.
Okay, Mark, you could give me a rapid fire, and then I got another question for you, Mark.
I still
will be the last question.
Sure. I mean, I haven't gotten a full sense of what the implications for Clubhouse may be, and my impression is that it's this platform where someone is actively producing a podcast and they do a conversation, if you invite to talk, and then you just get to listen in. But to Ricky's point, it is, no less or no more secret probably to a material degree at something like Twitter or Stitch or anything that's going to stream. So be careful to share, and don't rely on things like promises that this gets deleted afterwards so there's no recording, because someone might be recording. So again, take with a huge grain of salt the promises of these platforms and also the promises of freedom from these platforms.
Oh, that's great advice. Wonderful. Final question. We got 2 minutes. I think I saw the hand for 5 minutes. Do you think the Australian law and what we're seeing there with Facebook and Google could influence global law, like we saw GDPR kind of influence global law because these corporations are impacted?
So the Australian law was modeled off of a couple of similar laws in Europe. I think France had one in particular that didn't cause as much of a stir because of how it's structured. And New Zealand is already thinking about making their own version of the law right now. At first, I would not think that you would see that type of coordination, but given the seamlessness of how data can be shared and how Facebook reacted, they kind of damaged their brand a little bit by showing that they could cut the water off. Especially when they blocked global content to Australian users, that was kind of dramatic. I think it was very recently there was some impediments removed around producing a global tax on digital media companies, in particular gigantic tech companies that drive revenue around the entire world. And so when you see that type of coordination being done, it starts becoming a little bit more conceivable when other countries are starting to say, hey, yeah, my news media industry is being destroyed. Hey, yeah, my news media industry is being destroyed. You could see a potential for enough hey, yeahs to turn into some more coordinated action. I have not drained, the issue around, personal data on it, but personal liberty through these platforms is something that may be a mover towards that, especially when you talk about the influence that these platforms have on public dialogue. So I wouldn't, say it's impossible.
Okay.
And Charlie, I know that was going to be the last question, but you had talked about for the students and for practitioners as well, gaps where somebody could fill something in. This is something that happened today. The band Kings of Leon is issuing their album as an NFT, a non-fungible token. We're going to start hearing a lot about NFTs and what they are and what the laws are going to be around them and possession of them, creating them. That's a place to really look into because it's happening right now. And if we're saying that the DMCA from '98 was taking way too long to catch up, it's going to take even longer to catch up with what we do with NFTs.
Man, I hate you would drop that on us at the end. I got some side stuff that NFT just came to me too, and you're absolutely right. I was about to kind of put a bow on that. This is an area. There's content protection, what to do with it. If you're looking for a career, this is going to be a very hot area. Thank you. You did a marvelous job. This is so interesting. Thank you. We now have a break. We kind of went over 1 minute, 12:15. We're going to start the CLE portion, and we'll be right back here. And we'll have welcome remarks from Esther Lim, and we'll start our judicial panel. So join me, as our tradition, in giving a round of applause to this panel. And we thank you. Get a break and come back here at 12:15. Thank you.